Estateically speaking, with yours truly every second and fourth Friday as of November 2021. You can contact us at the information on screen.
Sell it, buy it, rent it, lease it.
KMC Property Services, making your real estate dream a reality.
tips and then I'm going to go in detail. So tip number one, discover what you want or can afford. Opt for a house that will not jeopardize other financial dreams. Prepare by having an emergency fund and save enough for a down payment. Then repair your credit and lower your debt burden. Practice paying the mortgage. And finally, obtain a mortgage with best interest at heart. So I'm going to go in detail with each of them. So
Tune into our live stream, Real Speaking, with yours truly every second and fourth Friday as of November 2021. You can contact us at the information on screen.
Welcome everyone to this, our third episode of Real Speaking and more. I'm your host, Karen Koch, and with me this evening is a very special guest, Miss Rudeine Speid. And of course, you would have all seen the flyers, as to what she's gonna speak about and all of that. So I'll get to that in a few minutes. Okay, and so tonight we're happy to be here. We're happy that you could be with us, those of you who are on. I'm going to ask you please just to type your name in the chat. Listen keenly, because tonight you are in for a treat. Surprises and prizes. So make sure that you are listening keenly. And if you are one of those who attended all 3 episodes, then I would love for you to place your name in the chat and indicate so that you have seen all 3. All right. So please state which platform you're viewing from. I would be happy to hear from you. I'm happy to reach out to you if you have any special real estate need, you or anyone you know. All right, so tonight's quote is, buying real estate is not the best way. Buying real estate is not only the best way, the quickest way, the safest way, but the only way to become wealthy. And this was written by a gentleman named Marshall Field. All right. So I'm just going to wait a few more minutes. I'm just going to play our jingle while we wait a few more minutes for a few more persons to come on.
Tune into our live stream, Real Speaking, with yours truly every second and fourth Friday as of November 2021. You can contact us at the information on screen.
All right, everyone. I am going to introduce our special guest, and Mrs. Miss Rudeine Speid is an attorney at law. She's the owner of Speid Law, and she's also a Realtor associate, and she's attached with KMC Property Services. Ladies and gentlemen, please make welcome Miss Rudeine Speid, and she will just elaborate a little more and tell us a little more about herself when she comes on screen. So in a few minutes, she will tell us just a little bit more, and then we go right into our question and answer session.
Hi, good night, everyone. Thanks for having me, Karen.
You're welcome.
All right, so I guess just a little summary. I'm a practitioner, a civil practitioner. It means I don't do any criminal matters. I've been in practice for 9 years and counting. Not sure what else we need to know. I guess when the question and answer starts up, then I can get a bit more detail depending on what our viewers would like to hear.
Okay. Thank you so much for that brief introduction.
You're welcome.
All right. So I'll just go right into our question and answer. Miss Speed, do you specialize in any other aspect of law, or are you a general practitioner?
So attorneys can be civil, criminal, or both. I do solely criminal matters. Solely civil matters. So it means I don't do anything criminal. In terms of specializing, I do a lot of conveyancing, meaning buying and selling of property. We also do a lot of divorces. Uh, the probate industry has boomed. There are a lot of persons doing wills now. So we do a lot of those matters as well.
Okay, great. And my next question to you, what does the closing cost entail?
All right, so your closing costs, if you're a purchaser, it's not really that much. You have the stamp duty, which is a fee that's paid to the government. This is 2,500, so that's the easy one. There is also the registration fee. It's the purchasers or the seller's portion is 0.25% of the sale price. There is also what we call a letters of possession fee. Some attorneys will see a miscellaneous fee. That is usually dependent on the attorney. The industry standard is about $20,000 to be shared between the purchaser and the vendor. What this allows you to do is to get those letters that you would take to the utility companies to have your electricity placed in your name, the water placed in your name, and for your name to be added to the tax roll. The only other thing you might have at the end of closing is the rest of your attorney's fees.
Okay, thank you.
Yeah.
All right. What is a title and what are the different types?
Okay, so a title is a document that identifies who the owner of a particular parcel of land is. So on the title, you will have an identifying number, that's a volume and folio number. It's a unique number to that particular parcel of land. As well as on the title, you'll have a description of the property. Sometimes it might just be an address. For properties in the more rural areas, sometimes it's just identified by the size of the property. You find that for Kingston, St. Catherine, the titles are a little more evolved, but for the rural areas, sometimes you'll just see square meters in a parish. And then there might be a plan attached to it that will explain where it's located, but that's pretty much it. In terms of, I think you asked the different types of titles.
Yes.
It's not that there are different types in the true sense of the word because there's really just one title. What we have is different kinds of lands, as we loosely say. We have registered land, which is what we usually have a title for, and you have unregistered property, which are those properties where there's no fixed title. So what you will have is maybe a piece of paper to say John Brown sold it to Mary Jane, and then that's a little more work in terms of establishing who the true owner is. So as best as possible, we always encourage persons to try, when they're purchasing land, to get land that actually has a registered title. And in fact, many of the financial institutions now won't give you a mortgage unless there's an actual title for the property. So we're looking at registered and unregistered land as opposed to different types of title.
Okay. All right, well said. Which tenancy would you recommend for 2 or more purchasers?
Okay, well, that actually depends on the individual purchasers. And I would say every situation is different. So there are two types of tenancies that you can hold a property in. You have joint tenants and you have tenants in common. Joint tenants deals with the issue of survivorship. So my easiest way to explain it to my clients is whoever dies last gets everything. So that means that if there are two persons or three persons on the title, once one person passes, their share goes to the next person and so forth. So whoever is the last man standing gets it all. There is also and those tenancies are usually more common between spouses, because it allows you to avoid the issue of paying certain taxes, and it makes a transfer much easier, for you to be able to deal with the property after the passing of the other title holder. The other option is tenants in common. And what that means is that each title holder will always hold a portion of the property. So once you pass, your interest goes to your estate as opposed to the other title holder. So it means that you can either will it or it will go down through the usual administration line. Now, the beauty about tenants in common is that you can decide how much interest each person holds in the property. With joint tenants, no matter what, you each hold a 50-50% interest. So with tenants in common, if it's two persons, for example, you can still do 50-50. Or you can do 60-40, 70-30, 80-20, and so on, whatever you decide to do. If it's three of you, then again, you can split it in three equally, or you can give different shares based on maybe the contribution of each person towards a purchase. So if you put in $10 and the property is worth 50, then your share will be adjusted accordingly. So it really depends on the particular situation. So it's not just clear cut, just to just pick one. You really have to think about what you want to do.
Okay. Why does a seller need an attorney?
Sure. Well, both parties need an attorney, but especially for the seller, the sale is a very involved process, especially if you have a mortgage on the property. So financial institutions, if you try to do a sale matter on your own and there's a mortgage on it, they're not going to pay you too much mind because they have to receive assurances that they will get the money that is due to them. So for instance, in order for the purchaser's interest to be noted on the title, the mortgage holder has to release the title to an attorney, which means they remove their interest before they even get paid. So that's not something they'll trust to an individual. Sorry, that's one. The selling of a process also has very involved stages. The preparing of the sale documents is very important. Um, some persons take it for granted that a sale agreement is literally just saying, I agree to sell to someone for a fixed price. There's a lot more involved in the process than that. Sorry, your attorney probably wouldn't sit down and explain it all to you, but for selling a property, there are things we have to ensure in place in terms of the title. We have to do searches to make sure that there are no caveats lodged against the property, which is the same thing for a buyer. We have to make sure that everything can actually be sold. So for instance, you have a lot of persons who they'll have a property with somebody else, the person dies, and they get up tomorrow and they try to sell it. It's not as simple as that. So you have to have an attorney to actually take you through the entire process because it's very involved. And it's very cumbersome and a bit of a headache if you're not experienced in the actual field. So we actually need the attorney to protect your interests, to ensure that you get the sums that are due to you, to ensure that you get it in as much a timely manner as possible. So it's not something you can really do alone. Just the submitting of documents to the government can be a headache. So you actually need someone experienced to actually hold your hand and take you through the process. For me, I tell my clients, you know, all you need to do, you sign a sale agreement, you transfer, and you wait on your money. But they don't understand there's so much involved in this process that if they actually got into it, they'd probably give up.
Okay, so can you elaborate now? Why does
Mhm.
the buyer need
Sure.
an
All
attorney,
right.
please?
So when a buyer gets an agreement for sale, this is a short agreement for sale, might be a 6-page document. Someone has to go through that document because in the legal field, one word can make a difference. A lot of persons don't understand that if they don't honor their obligations under a sale agreement, they run the risk of forfeiting, as in losing their entire deposit. So imagine you've paid a deposit of $1 million, and because you didn't understand what you signed on to, you've lost that $1 million just outright. Not illegally, not a backhand deal or anything. There are many obligations under a sale agreement that the purchaser has to deal with, and they need to understand what it is that those things are. There are issues in terms of timeline for presentation of documents, getting surveyor's report, valuation reports. The attorney also has to check to ensure that what is being sold is a valid piece of property. We've had several issues, I mean, in Jamaica and across the globe, where persons have bought land that are in the middle of the ocean, as in the land doesn't exist, but they were presented with a title and thought it was fine. And so you do need an attorney to protect your interests. Make sure that you're actually purchasing what you aim to purchase. Make sure that you're actually purchasing it for fair value. Make sure that when you're purchasing, there are no issues with the property. So I've had matters come in where the name on the title is not the name on the sales agreement, but I know what to do to address issues like that. A purchaser wouldn't necessarily know the starting point. There are persons who get documents and don't read, and you sign away, and as Jamaicans say, you sign away your rights. So you do need someone to hold your hand through the process, explain to you all these legal jargons, explain things to you so that you're actually safe and secure in your purchase. Ensure that when your purchase is finished, that everything that needs to be done is done. So the taxes are sorted out, the water bill is sorted out, that you can actually get your keys and move into your property, and be comfortable where that's concerned.
Okay, thank you so much for that. All right, our next question is, what is a notation of death on a title?
Okay. All right. So you will have titles where there's more than one registered proprietor. If it's joint tenants, in order for the interest to transfer to the surviving title holder to allow them to be able to deal with the property, and by deal I mean sell, the death of the other registered proprietor has to be, what we'll say, endorsed on the title. I don't want to say noted again, endorsed on the title. So once that endorsement is made, then the public or your attorney now knows that yes, this person solely has the authority to sell the property. Because once there are more than one title holders, both or however many they are, they have to be involved in the sale process. So if the death is not noted, then the property really can't be sold.
Okay, thanks again. What is a mortgage deed?
All right. So a mortgage deed is what your financial, and your as in the purchaser, your financial institution will prepare to outline the terms and conditions of your mortgage. This is what secures the bank, so to speak, or NHT, to lend you the money, and it has conditions in terms of how you will repay, your interest rate, your monthly payments, things like that. The mortgage deed is very important because a lot of people don't understand, and this is why lawyers are very important. A lot of people don't understand when they sign these mortgage deeds what their obligations are. So a mortgage deed will have terms where they'll say to you, you're not allowed to do anything to the property without their permission. So for instance, if you want to add on to the property, these deeds will tell you that you really need to consult with a mortgage company first before you make these additions to the property. The mortgage deeds will explain to you that the mortgage company has the right to come to the property, look at it, see if there are anything wrong with it, come in, require you to fix it or fix it themselves, and then add it to your mortgage. These deeds explain in terms of insurance purposes, that your buildings have to be insured. They have to be the recipient. So this mortgage deed is a very involved document. Also, one of those very long documents with a lot of legal jargons that is good to have someone explain to you what your obligations are. So the purpose of the deed really is like a contract between you and your financial institution to put their name on the title, lend you the money, and secure the repayment of their principal and interest.
Okay, thank you. What is the administration of a will? And this is a three part question. So what I'll do, I'll let you answer the first part and then I'll go
Okay.
right along with the rest of it.
All right. So when there's a will involved, we normally say we probate the will. The administration we usually refer to when the person has passed, sorry, when the person has passed and they don't actually have a will. So, in order for you to have the will probated, what it means is that you have to make an application to the Supreme Court of Jamaica to determine that the will is valid and that whoever is listed as executor, sorry, or executors will actually be allowed to deal with the property of the deceased person. So normally the will outline who is in charge of the estate. So it would normally say John Brown is my executor. I empower him to do certain things. I empower him to pay my funeral expenses. I empower him to distribute my assets in the manner that I think fit. Now, the application again is one of those things that you really need an attorney to do because it's not a simple process. When you take a will into an attorney, the first thing they have to do, sorry, is to check that the will is in keeping with the rules of making a will. So you have will forms in bookstores that persons will fill out, but if it's not done properly, it's really of no effect. So you can use a will form if you have guidance as to what to do, but we really do recommend that you get an attorney to do those wills for you. So in order to probate the will, we apply to the court for the court to one determine that the will is valid and to appoint a particular person in charge of your estate. Now, once this person receives a grant of probate, it means with that one single sheet of paper, they can go anywhere in the island of Jamaica and take over any asset that is in your name or in which you have an interest, and then give it to whoever the will indicates that they need to give it to.
Okay, so basically you would have answered
All the
part
questions.
B and part C by your answer.
Yes. Yes,
All
and
right.
yes, we do offer the service of writing the will, and we always encourage persons because sometimes you will have a property, and Jamaicans tend to do this thing where they said, this is my house, but then the house is in your sister's name. So they'll say it's my house because they paid for it, but legally the house is your sister's. So it's important that you actually come into us, show us what you have, and we'll explain to you what you need to do to get your house in order.
Okay, great, awesome. What advice would you give to a buyer who wishes to share attorney with the vendor?
Okay. Well, first of all, don't do it. It is actually against our ethics to do that. But as a practice, for me personally, I don't recommend it because here's a problem you have. When you go to an attorney, that's as people say, this is my lawyer. Yeah. You're selling, this is your lawyer. You're buying, it's the same lawyer. If you have a problem, who does the lawyer act in the best interest of? So, the attorney has to pick a side, and you really don't want to end up on the losing side. So, you need to have someone who is fighting for you only and doesn't have a conflict of interest with any other party in the sale. I have a lot of family members, one family member selling to the other who want to come to me and use me to act for both parties. I don't do it. because things can crop up really easily. There's a breach on the property, there's an issue with the purchaser getting their financing. I have to advise a certain way, and my advice for a purchaser would not be the same as my advice for a vendor. So I never ever recommend it. And in fact, a lot of persons would want to purchase, as purchase would want to go without an attorney. Again, I can't stress it enough, don't do it. You really need to have someone in your corner, and that's what your lawyer is for. So it's cheaper, some persons think, to use the same attorney, but as we say, sometimes the cheapest become the dearest. Just don't do it.
Food for thought. What is your role in the correction of a breach on a property and the potential cost?
Okay. Well, the first thing that persons need to understand is there are two type of breaches, as we casually say. You can have a breach that is within the boundaries of the property, as in within the four walls of the property, right? If you have a breach like that, your sale can continue or your purchase can continue, because what will be required is that your attorney can give an undertaking to your financial institution that they'll rectify the breach, and then the matter can go on. The other breach that's a problem is where there's an encroachment, which means either a part of the building or the wall for the property has gone onto someone else's land, or vice versa. Once there's an encroachment, your sale falls through completely, because the mortgage company can't control what a third party has done. So we try to avoid encroachments as much as possible, because it really does affect the sale. There's really nothing to go on unless it's a cash purchase and they choose to take the property with a breach, but then somebody has to fix it at some point. So I really don't recommend, because in order to rectify a breach, there has to be either, well, depending on what it is. So say your wall is over the boundary, you can hit the wall down and rebuild it. That's the cost you have to worry about. But say the breach is because the building is too close to the boundary. Hitting it off might not be the most sensible thing to do or practical thing to do. So what it means is that we actually have to apply to the Supreme Court for the title to be amended, which can be a costly process. You have to have a plan redrawn to fit in this extension. There are attorneys fees involved, there are updating of titles fees involved. Depending on the extent of the breach, this can run you between 300 to 500,000.
Wow.
Yes. And so, and,
So,
and I should add, Karen, and this is why it's important to have an attorney, because as a purchaser, parties are free to agree to whatever they want to do. And sometimes a purchaser will say, you know what, I'll fix the breach, not really appreciating the cost involved in doing it. And so, you really have to sit down with your counsel and discuss what your options are and what really makes sense for you.
yeah, well, yeah, definitely.
Yeah.
Okay, what is a commitment letter
Okay.
and a letter of undertaking?
Okay, sure. All right. So what happens is that when you apply to your financial institution for a loan, they provide you with what they call a letter of commitment, which is your promise ring. Let's look at it that way, or your engagement ring. So they'll give you this letter to say, yes, I will give you a particular sum of money towards the purchase of your property. This applies to the purchasers only, by the way. So your institution will say, yes, I'll commit to paying $10 towards the purchase of this property. And the commitment letter will outline what your monthly mortgage is going to be and details like that. Now, the thing with the letter of the commitment is that just with your engagement ring, the bank can change their mind and say they're not going to go ahead with the transaction. Normally, this will only happen if during their investigations they discover something maybe fraudulent with your application, or having done a better look at the property, they realize there might be structural issues where the property won't outlast the life of the loan. So, for instance, the building might be in such a disrepair that, based on that structural engineer report, it doesn't seem that you'll last more than 30 years, but then you're taking a loan that's going to take you 50 years. So, the letter of commitment is revocable. The letter of undertaking now is when you go to the altar and you get married. So once a bank gives you this letter of undertaking, this is as good as cash in hand, as I like to say. It's not something that they can just take back because they've said, I will do this. And so once you get that letter of undertaking as a purchaser, you're comfortable. It's just a matter of waiting. As a vendor, your money is on its way. So that's really the difference, the best way to explain it. So the undertaking is the actual wedding itself.
Wow. At what stage of the buying process are they, or is each needed or required?
Okay, well, it actually depends on your agreement for sale. The typical sale takes about 120 days. But you have some matters that want it shut down in 90 days. If it's a cash sale, then we hit 45 days. So if it's a 90-day sale, your letter of commitment is usually required within about 30 to 45 days of signing the sales agreement. If it's a 120-day sale, we usually request that within 60 days of the agreement for sale date. If it's for as it relates to letter of undertaking, if it's a 90-day sale, we usually want that by about 60 days into the agreement. If it's a 120-day sale, we usually want that within 90 days of the agreement for sale date. Now, the thing about it is when you're using financial institutions, especially with COVID, and especially sometimes with the government financial institutions, they take a bit more time. So we always try to do a 120-day sale, which is the average. And so it would mean that your commitment is due within 60 days and your undertaking is due within 90 days. Once, in order to get the letter of commitment, though, the purchaser has to do a lot of legwork in terms of getting their documents together to get to their financial institution. But once you get the letter of commitment, there's usually nothing much for you to do for the undertaking to be issued. Normally, then you'd probably just need to sign the mortgage deed, stuff like that, and you'll get your undertaking.
I'm not hearing you.
Oh, I'm sorry. Are you hearing me now?
Yes, I am. Sorry.
Right.
Can you please
So
repeat the last one?
I'll just repeat the last part. So if we do the standard 120-day sale, your letter
Mm-hmm.
of commitment is due within 60 days. Once your financial institution has issued that as a purchaser, there isn't much for you to do after that. Your financial institution, their attorneys will do the processing and issue the letter of undertaking within the 90 days.
Okay. Okay. All right. So that brings us to the end of our question and answer. And I'm going to ask anyone who is online, you have questions for Miss Speid, could you please place it in the chat or that we can have it addressed as best as possible. If you have a question in relation to what she has discussed a while ago, or if you have any other question, then that will be fine. You can still go ahead and place the question in the chat.
Right. And for persons who are shy, you can actually set up a consultation with my office, and then we can actually go into more detail because, in terms of buying and selling land, there are a lot of fees involved. There are a lot of things involved, and sometimes it's good to sit down and have that one-way discussion so you can actually have an idea of what you're doing. Especially for the purchasers, it's important that you get a breakdown of all the costs involved, because sometimes it kind of creeps up on you because a lot of persons think that when you see a sale price of $10, they only need $10 in order to close a transaction. So it's good to come in and let us go through step by step as to the amount of money you will need and when you need to get it by. So that's one of the reasons again why it's important to have an attorney, because we can work with you based on your finances to determine what are your best options going forward. Because I do have persons that come in, they don't have the full amount of money that they need, but we work with them to get them to be able to make that purchase. So you can contact my office. It's Speed Law. We do have a WhatsApp line. The number is 876-815-5097. Again, that's 876-815-5097. So if you can't reach us by phone, then you can just send a message and we'll try and work everything out with you. We also try to be very flexible with our clients because we appreciate that a lot of persons can't come to us during the week or during regular office hours. So if you call, we can actually set up a consult with you outside of the 5 p.m., outside of the usual 9 to 5, or on Saturdays for those persons who really have a difficulty.
All right. I want to thank you so much for, such a very insightful and in-depth explanation, of what you do, and from now on, I guess most of us will be a little more literate concerning legal matters.
Yes.
Concerning legal matters, yeah.
Yeah,
And
it's a lot, and that's what we're here for.
I am in the business, and a lot of these things will come my way, and I will, ask you a thing or two,
Yes.
and you will explain it to me. But it's like I learn more and more every day. So, it is really, really, really a very good thing for you to have come and shared with us, and we are so grateful. All
You're
right, so
welcome.
thank you so much, Miss Speed. And please put whatever other information in the chat. And I don't want anyone to go because I have some prizes that I want to give. And I need you to stick around, stick and stay with me.
Sure, no problem.
All right,
All
so
right. Good
please,
night, everyone. And you can
thanks
still send
again.
your questions in the chat. I'll be here for a bit, so I'll answer as they come.
All right, thank you.
You're welcome.
So everyone, I'm going to ask you please to subscribe to my YouTube channel. You are to like my Facebook page. And of course, we want to thank you once again for joining us. This is the last episode for this year, because I know that you all want to go, on your holiday spree. So what you call it? No, I won't in any way bombard you with any more for the rest of this year. So today was in fact our final episode for this year. And come January 2021, I'm going to ask you all to join us January 7th, Friday, January 7th, 2022. Real speaking and more. We will have another special guest, and her name is Mrs. Karen Barrett Bennett, and she's also a team member of KMC Property Services. And she will go through with us ways in which the Realtor can assist you in achieving your real estate goal. All right, so as of course, I said to you that we have some prizes. I don't want you to go. All right, I don't want you to go, so please do not go. Please do not go. So KMC Property Services has been around since over the COVID period we started, and we have been making our presence felt. My name is Karen Cope, for those who did not get my name, and I am the dealer and the owner of KMC Property Services. And I've been in the real estate business for over 13 years, and I have been serving clients both locally and internationally. I have clients, right across the globe in some places that, one would never think of. But that is the nature of our business. I am a certified international property specialist as well. So, that will give you an idea. So when you have that title, you have to be able to serve people internationally. So that being said, I want you all, as I said before, to go like my YouTube, to go subscribe to my YouTube page, and also to like my Facebook page. Now, I have some special prizes for some special persons who have joined our broadcast, and I am going to ask some questions, and you can place it in the chat because I want to be able to give them away. So here's my first question. The first question that I would, the first prize that I would like to give, the question goes like this. It goes to the person who attended the 3 broadcasts and for you to tell me what were the topics. So I'm going to be looking in the chat to see such a person who can give me that answer. And the next one, well, I'm looking. I'm not seeing anything in the chat right just yet. All right, so my next question is, who is a real estate dealer for KMC and how many years has she been practicing in the business? I just told you a while ago. Who is the real estate dealer of KMC Property Services and how many years has she been practicing real estate? Not seeing anything. And post comments. All right, my number is 3640198. So I'm going to ask you to send me. I'm not sure why you're not able to post the information in the chat, but I'm going to ask you to WhatsApp me. It's 3640198. 3640198. All right, so the third question is, what is KMC Property Services tagline? What is KMC Property Services tagline? So I'm awaiting those answers because I have some special prizes that I'd like to give for your holiday gifts. So those of you, you maybe, Santa may not come your way this way, but I'm not Santa. I'm just a bearer of good gifts, all right? All right. So this is a very nice way to end today's segment. A very happy and a very peaceful holiday to everyone and your family. And I trust that everyone will arrive alive for 2022, and that we can all come back again and listen to, all these wonderful broadcasts that we have lined up for you to educate you on financial matters and on real estate matters. Thank you, thank you, thank you once again. I'm gonna show Miss Speid's information again on the screen. For those of you who did not get a chance to see it, please make note of it. And she said she is available for one-on-one consultation. She will give you an initial free consultation, so please feel free to take advantage of that. Have a very good night and all the very best to you and your family. Bye.